You are watching the LemonAid Podcast with Amar Law Group. Join us as we unlock the secrets and expert tips you need to know now.
Hey everybody, welcome back to an all-new episode of the LemonAid Podcast with experienced attorney Shalev Amar. I'm your host, Mike Leon. On this podcast, we discuss lemon laws and how they protect consumers from defective vehicles. And in today's episode, we're going to be specifically talking about the playbook manufacturers use when they don't want to take responsibility for selling you a lemon. From blaming the driver to calling repairs goodwill, these companies have plenty of ways to dodge the accountability. But luckily for us, Shalev knows how to fight those battles. So Shalev, good to see you, my friend. Let's talk about what are some strategies you have seen in your experience that manufacturers use to try to deny a valid lemon law claim.
Good to see you too, Mike. There's several strategies that they have. For one, and it's typically not the manufacturer directly, it's their authorized repairing dealers. But in any event, they oftentimes will say user error, or they'll say no problem found, operating as designed, unable to duplicate, or they'll try and blame wear and tear or say lack of maintenance. So sometimes they'll even allege abuse or misuse, even if the vehicle is not really being misused or abused at all. So they have all kinds of spaghetti that they could try and throw at a wall to try and avoid lemoning a vehicle.
Speaking of spaghetti at the wall, you've mentioned in a previous episode that sometimes they label the repair as goodwill. So why do they do that? Explain that if you can, and how does it affect the consumer's rights?
Sure. Well, when a manufacturer labels a warranty repair, what should be a warranty repair as goodwill, what it means is, you know what, it's not under warranty. And the reason why they do that is because lemon laws are warranty enforcement statutes. The manufacturer provides a warranty. It's basically an assurance of quality on the vehicle. They'll operate properly for a designated amount of miles in time, typically 3 years, 36,000 miles, or 4 years, 50,000 miles, bumper to bumper. The powertrain warranties tend to be longer, 5 years, 60,000 miles, etc. Some companies even have 10-year, 100,000 mile powertrain warranties. Some battery warranties for electric vehicles are 10 years, 100,000 miles. But in any event, goodwill just means, well, you know what, it's not covered by warranty, so we're doing this out of the goodness of our heart, not because it's a required warranty repair. And so goodwill is a way of avoiding warranty coverage. They still pay for the repair, they still do the repair, but in the repair documents, they call it goodwill. And then later on, if you argue that you have a lemon vehicle, they can say, well, certain repairs don't count because we did them as goodwill. They were not under warranty, and so therefore the lemon law doesn't apply. So goodwill is, look, sometimes it is legitimately goodwill. Here's what I consider legitimate goodwill. If the warranty is expired and they're doing a repair despite the warranty being expired, that's legitimate goodwill. If it is actually an issue caused by the driver, say, the driver drove over a curb and that caused an alignment issue, and that's done as goodwill. That's true goodwill. But if it's a legitimate defect, something wrong with the way it was put together, defects in materials or workmanship, then that should not be considered goodwill. But sometimes they do try and call legitimate repairs goodwill, especially if it's a recurrent problem. And now we'd be like, oh, well, this time it wasn't under warranty, it was goodwill, so it doesn't count towards the lemon.
You just mentioned a second ago that about blaming the customers for misuse of the vehicle. I would love for you to go back. How do manufacturers try this in terms of blaming the misuse or abuse of the vehicle? And then how do you address it for your clients?
Well, look, the ways that can be argued are almost infinite. But for example, they can try and say that the vehicle is being over-revved, or it's being driven off-road where it's not designed to be driven off-road. They can say that a vehicle is not being charged properly if it's an electric vehicle. They can say that the vehicle hasn't been maintained properly, that the oil changes haven't been done at the proper cadence. They can claim that the vehicle has not had other maintenance done, like fluid changes, like radiator fluid, etc., and that certain items might be wear and tear, like brake pads or batteries, stuff like that. And so there's a variety of ways where the company can say either the vehicle has been misused or not properly maintained.
So, delays also seem like another strategy. Maybe they'll keep the car in the shop too long, they'll string the repairs along. What does that look like actually in practice? I've had that happen to me, but what does it look like in practice? How does the law treat it?
Well, here's the way delays work. If the repair has been started and it takes too long, that actually can render the company liable under the Lemon Law. Most Lemon Laws have a 30 calendar day presumption for time out of service, where the law says, hey, enough is enough, that's too long. It doesn't have to be consecutive. It's typically cumulative, meaning adding up all of the repair attempts, the time out of service. If it totals 30 or more days, typically that would qualify as 11. But the way delay can be used is by, for example, delaying your repair appointment, saying like, oh, well, we can't get you in for another month or so, or delaying starting the repair, even though your vehicle is at the repair shop. Then they can argue, well, we didn't even start the repair till a week or two later. We argue that repair time should still count towards the law, but it at least gives them an argument. So that's typically the way that delays are used in these types of cases.
What about lowball offers that we see sometimes? So how do you advise clients in that situation when they get a lowball offer and they know that this is way less than what they're entitled to?
What we tell our clients when we get a lowball offer is, look, this is negotiation 101. The company, they want to pay as little as possible to resolve a Lemon Law or breach of warranty claim. They're just looking at dollars and cents and their operating expenses. They want to pay you as little as possible. The way they're also looking at it is that if they start too high, then it gives them less room to negotiate, or they might end up paying more than they feel comfortable paying in a particular case. So the number one thing I tell clients when we receive a lowball offer is, hey, don't take this personally. Don't be offended. It is a lowball offer. It's not even close to what you're entitled to. But at the end of the day, the initial offer doesn't matter. The final offer is what matters. The initial offer only matters if it's given in a take it or leave it basis. But other than that, it's a negotiation, and they start low, we start high, and we try and meet somewhere in the middle that both sides can live with.
Shalev, a second ago, you were just talking about some of these records that the manufacturer will use against you. So how important is saving documentation, when they try these tactics? And what kind of record should you be saving so that way it makes a difference in your case?
The number one piece of evidence in a Lemon Law breach of warranty case is what's called a repair order. It's basically the repair invoices from when you get your vehicle repaired. It's showing what the complaint was, whether it was confirmed or not, what the defect repairs were, and whether they were covered by warranty. Extremely important. Those records also show the time in the repair shop, the mileage, etc. That is the number one piece of evidence in these cases. What could also be important, though, is your correspondence with the repairing dealer or the manufacturer, and that could be texts or emails regarding the vehicle repair issues. That's very important to keep as well. And if you've had to record a problem that you're experiencing, a defect issue, it's extremely important to keep video recordings of the problem as well, if you have those. And this varies by state, so always check your local state law. But in some states, you are allowed to record conversations. And if you're allowed to record conversations, we recommend that you do that. That prevents he said, she said situations when it comes to repair issues.
Shalev, do you have any examples that you could share with the audience of where a manufacturer tried to dodge responsibility, you stepped in, you were able to turn it around for your client? Anything that's top of mind that you would like to share?
Well, I would say it's most of the cases that come to us. I would say of the majority of cases that come to us, manufacturers just did not accept responsibility. Sometimes people are even told, not necessarily by a manufacturer, but sometimes by a local dealer, oh, well, there's no lemon law in this state, or the lemon law doesn't apply to your vehicle. Sometimes people will go through the manufacturer's ADR process, which stands for Alternative Dispute Resolution. And oftentimes those processes, unfortunately, are biased. They're not supposed to be, but they tend to be. For example, our out-of-court resolution percentage is 95% of the cases that we take on historically, we're able to ultimately resolve out of court. And I can tell you the percentages are dramatically lower for defendant ADR processes like arbitration. In fact, I remember years ago I saw a crazy low percentage of like 20%, which is just ridiculous. We used it against the company in a court case. And of course, they took the statistics down online after we did that. But it was just a crazy low percentage. So that's kind of the ways that manufacturers try and avoid responsibility. But once people come to us, the companies have to take the cases seriously, because we're one of the firms where if they do not offer something fair out of court, we are willing to litigate if our client's on board with litigating. And the companies know which firms are willing to litigate and which ones aren't. And because of that, they take it seriously when they get a letter from us, because they know at that point, okay, we can't play games anymore. We have to take this seriously.
Shalev, for a customer that's listening today, what are some warning signs you would advise them to look out for when a manufacturer is clearly trying to avoid taking any responsibility under a lemon law?
Oftentimes, a manufacturer will sweet talk you and act very empathetic with your situation. Gosh, I'm sorry you're going through this. It must be really frustrating. But it's basically empathy without providing any tangible resolution. They're sweet talking you. They're being empathetic. They're saying like, gosh, I would feel the same way if I was you. Please let me know if you have any further repair issues. But they're not doing anything. They're not compensating you. They're not taking the vehicle back. They're not extending your warranty. And oftentimes, even if they do extend the warranty or provide you a couple of free oil changes, that's not even close to what the law entitles you to. And so these are typical. The most common tactic of the manufacturer, again, is to basically empathize but not do anything to resolve the problem for you substantively.
Shalev, thank you for the time and insights on this. We truly appreciate it, as always.
You're welcome, Mike.
And thank you to everybody out there listening to another installment of the LemonAid Podcast with Lemon Law attorney Shalev Amar. Look, if you feel like the manufacturer, they're giving you the runaround, they're giving you lowball offers, you don't have to accept these excuses. Enough is enough. Do me a favor right now. Visit lemonlawadvocates.com. And if you live in one of these states, put your state in front of the URL. So Arizona, Oregon, Washington, Utah, Colorado, Minnesota, or New Mexico, you'll type in New Mexico, lemonlawadvocates.com. For those of you in California, type California, lemonlawadvocate.com. And for those of you in Nevada, go to nevadalemonlaw.info, or you can just call 866-904-2627 for a free lemon law evaluation with Amar and the team. And with Amar Law Group's fair fee guarantee, you'll never pay more in attorney's fees than you recover for cash and keep resolutions. Don't forget to like, subscribe, leave a review, and comment or share this episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and comment below.